In this video, we take a look at the latest XRP news. Will XRP be able to fly to the moon? Right answers in the comments. Ripple's chief legal officer, CLO, Stuart Alderoty, has joined the chorus of those expressing dissatisfaction with SEC Chair Gary Gensler's appearance before Congress. As Ripple continues its legal struggle with the Securities and Exchange Commission's SEC over the categorization of XRP, Alderoty examines Gensler's statements during the hearing, notably his evasive replies on the subject of securities under U.S. law. According to Alderoty, Gensler seemed to smugly evade question after question, which irritated numerous members of Congress. The Ripple CLO, on the other hand, emphasizes a specific moment when Reps. Richie Torres of New York's 15th Congressional District tried to put Gensler on the spot. Rep. Torres highlighted concerns throughout the hearing about the SEC's wide understanding of an investment contract, which seems to include whatever the agency sees proper. Torres especially questioned the SEC chair on its use of the concept to classify practically all cryptocurrencies as securities, a move that Ripple and Coinbase have strongly opposed. Rep. Torres cited a recent study by 6 prominent legal experts, including a Yale University professor, that found no Supreme Court judgment has ever treated a scheme without a real contract as an investment contract as an investment contract. When he questioned Gensler whether there had been any earlier Supreme Court instances in which an investment relationship was held to be such in the absence of an express contract, the SEC chair's answer was evasive. Gensler elected not to respond directly, instead referring to the SEC's lawyers who are now engaged in pending legal proceedings. Rep. Torres called Gensler's dodge baffling, given that the investment contract concept is the foundation of the SEC's legal proceedings against cryptocurrency related firms. It remains to be seen if other cryptocurrency firms engaging in legal battles with the SEC would follow the congressman's logic in future court trials. As the Ripple SEC fight continues, the SEC chair's testimony emphasizes the need for clarity and uniformity in the categorization of digital assets in the U.S. legal framework. The unique viewpoint created here provides light on the criticism made at SEC Chair Gary Gensler by exposing his evasive comments and challenges to support the SEC's broader definition of an investment contract. The SEC filed an interlocutory appeal with the court after Judge Annalisa Torres ruled that programmatic XRP sales did not constitute as securities. This meant that the U.S. Securities and Exchange Commission, SEC, did not agree with the verdict, and although the court accepted the interlocutory appeal, pro-XRP lawyer John Deaton termed the action ludicrous as he dismantled the SEC's case. Deaton discussed the SEC's interlocutory appeal in a piece titled The Irony of Interlocutory Appeal. The essay, which was published on the Crypto Law website on Thursday, September 28, outlines how the appeal filing might wind up favoring Ripple. The pro-XRP lawyer notes that Judge Torres' decision to approve the request for appeal was anticipated, and the argument was that such an appeal would allow the judge to clarify her reasons for deciding in favor of Ripple. Notably, Replex reported that the XALS 39 clawbacks functionality, which is scheduled to launch on the XRP, is now up for vote. Ripple to David Schwartz got forward to give his opinions after the news was met with skepticism from community members. Schwartz has attempted to ease concerns of this new function. He began by explaining that the clawback functionality would allow token issuers to recover a particular number of issued tokens from existing holders. He said that he was originally opposed to the functionality since the XRP already had the freeze feature, which is identical to clawback. However, he said that the obvious contrast between clawback and the frozen function caused him to reconsider. Schwartz emphasized in his comparison that the clawback function would find a main use case in legal disputes. He feels that the opportunity to recoup some cash in the event of a disagreement relieves the token issuer of the legal responsibility. This protection, according to Schwartz, is crucial for complying with court orders. He feels that auditing protocols on the XRP will be challenging with the existing model without the clawback capability. As contrast to freeze, which is a more nuclear option, the Ripple key to define the capability as a tool that enables for surgical strikes to preserve the XRP intact. Overall, Schwartz said that this new capability is presently available in blockchains that house stablecoins. He pointed out that if the proposal fails to pass, token issuers would have to go to the trouble of activating the functionality in some manner. Other major players in the XRP ecosystem, including as Rathof Niemann, Woke, have also worked to debunk falsehoods concerning the clawback function. According to him, there is no hidden adjustment in the XRP ledger ecosystem. With the issues addressed, the clawback functionality will be implemented if 80 of existing validators vote in favor of the proposal. For the proposal to fly, the minimum threshold must also be maintained for at least 2 weeks. The XRP has undergone a considerable revision in recent months, with a number of changes suggested. The team behind the Exum wallet recommended a revamp of the XRP infrastructure to incentivize participation via incentives, as previously reported by the Crypto Basic. Spend the Bits, a payment protocol on the XRP, won the top position in the Ripple CBDC Innovate Award, a display of the ledger's exemplary work, recognizing the efforts of the core developers internationally. The community that supports the blockchain startup Ripple has opted to celebrate the earlier, partial triumph this weekend, even while the rest of the cryptocurrency world is waiting for the formal conclusion of the judicial fight that has been going on between Ripple and the United States Securities and Exchange Commission for quite some time. Ripple CEO Brad Garlinghouse, Stu David Schwartz, legal experts Jeremy Hogan and John E. Deaton, and a great number of other people were present at the proper party, which took place on September 30. This event brought together not only XRP and Ripple enthusiasts, but also people who were closely involved with the ecosystem and the lawsuit itself. Right before the party, Garlinghouse shared a few images with the audience that was gathered outside the venue and said that this event was a celebration of collective accomplishment and a reminder to the SEC that court decisions matter and that progress is worth fighting for. He went on to say that this event was a celebration of collective achievement and a reminder to the SEC that court decisions matter and that progress is worth fighting for. When giving his speech during the event, which also featured a star performance by Lenny Kravitz, Garlinghouse said that it was this village that beat the bully, referring to the XRP and Ripple community and its stand against the regulator, in a video that was shared in an X post by Cryptolaw on September 30. He said this in a video that was shared in an X post by Cryptolaw. Earlier, Cryptolaw published an article produced by Frank Francone, a policy others at the Centennial Institute and a California attorney. In the piece, Francone stated that the SEC's central argument failed almost completely under judicial scrutiny, which caused harm to a lot of innocent people in the process, and not just the defendants in the case. Cryptolaw also stated that the SEC's actions had harmed a lot of innocent people in the process. As the creator of Cryptolaw, John E. Deaton, also pointed out in a comment he made on Francone's arguments in the article headlined, "The SEC is not the king. 75x investors, users, developers, and small businesses have been screaming the above for 3 years," which was published in an X post on September 28. In the meanwhile, a lawyer named Bill Morgan brought attention to the disparities in the SEC's arbitrary enforcement by noting that Mark Berger was pro-crypto when it came to Ethereum, ETH, and its co-founder Joseph Lubin, but while he was deputy director of the Division of Enforcement, he sued Ripple. More recently, on October 1, Jeremy Hogan emphasized that back in the early 1980s, the SEC had attempted to pull the same thing as with XRP, but with gold, when inflation was high, and gold was the investment, and that the courts had put a stop to it at the time.